My name is Jeff Morgan and I am from Dallas, Texas. I want to provide an update to those people who have been following the Rustin Wright case in Parker County. This is cause number CV18-1452 in the interest of Rustin's son. In the district court, the 415th District Court in Parker County, Texas, the individual presiding over this is Judge Graham Quisenberry. I will no longer even call him the Honorable Judge Graham Quisenberry. I think he's dishonorable and abusive, and I think that when you hear what has happened, you will probably agree with me, and that perhaps Judge Graham Quisenberry needs to be investigated immediately, suspended from his duties, and investigated immediately. Now, the mother of this child, his name is Ashley Womack, and Ashley has now filed an emergency motion for injunctive relief. To the honorable or dishonorable judge of said court comes now petitioner Ashley Womack, who makes this emergency motion for injunctive relief, and in support thereof would show the following to the court. Number one, on September 20th, 2019, this court signed an order entitled Order on the Petitioner's Motion for Further Temporary Orders that states in pertinent part the following. It is ordered that neither party may take the child beyond Parker County, Texas, and contiguous counties until further order of the court. So here is a judge deciding what's going to happen with a child. Number two, on September 24th, 2019, this court issued a writ of attachment ordering the return of the child to Womack, Ashley Womack. Number three, on October 3rd, 2019, at the conclusions of the proceedings conducted in this case, and by the way, I was there for this case, I witnessed it. I saw what Ashley tried to do, and I met her allegedly abusive husband, a retired police officer that has been accused of abuse of this child. That's right, a retired police officer has been accused of abuse of this child, which is part of the reason the child did not want to go with his mother and the allegedly abusive stepfather. At the conclusions of the proceedings conducted in this case, the court ordered that the child, who was present in the courtroom, be turned over to Womack. Womack had not seen the child for more than a month. Number four, because of the events that occurred at the courthouse, and as more set out in Womack's affidavit, attached hereto as Exhibit A, in addition to other conduct of and statements by the child, Womack believes that the child is in immediate need of intense mental health treatment. This is what Womack is saying. Ashley Womack is saying that she believes the child is in immediate need of intense mental health treatment. I wonder if she would also agree that perhaps her husband, the retired police officer, the allegedly abusive stepfather, might be in need of immediate help for anger management and to not abuse. Number five, Womack has not been able to locate appropriate care for the child within the boundaries of Parker County, Texas, and its contiguous counties. However, Womack has located an appropriate treatment facility that is located outside of the restricted area. Therefore, Womack requests the court, without hearing, lift its temporary injunction or issue a temporary restraining order or a temporary injunction that modifies the present temporary injunction so that Womack may immediately take the child to the care facility. So she is requesting an order to take a child to a mental health facility. Everybody who knows the child, everybody who's talked with the child, knows this is rubbish. This entire thing is rubbish. It's garbage. But this is what she's giving to the judge. Number six, the requests made herein are in the best interest of the child. And this is that devilish, pernicious best interest of the child doctrine, which has no definition. And by the way, if Ashley Womack would be honest, according to the Hawley factors, which the Texas Supreme Court has upheld, the first criteria that we need to look at in the best interest of the child is where does the child want to live? That is number one. The third factor is there any physical or emotional danger to the child, which is what this child is alleging if he goes back to the home of Ashley Womack with her allegedly abusive husband. But nevertheless, Ashley Womack states the requests made herein are in the best interest of the child, and she is going to be presenting this to Judge Quisenberry. And of course, Judge Quisenberry, who, as one attorney told me, does not know the law, probably doesn't know what the best interest of the child is, and the reality is nobody really does. But Judge Quisenberry, with his black robe on, is probably somehow going to be able to pull this out of somewhere and determine that, yes, this is in the best interest of the child. The requests made herein are in the best interest of the child and are brought to prevent further harm to the child's physical, mental, and emotional well-being. Once again, I was with the child on October the 3rd. There was nothing wrong with him. He's an intelligent person. He is a healthy person. There is nothing in which he portrays himself as being emotionally unbalanced. On the contrary, once again, he is alleging abuse at the home of Ashley Womack with her retired police officer husband. Oh, and by the way, Judge Quisenberry conveniently does not want to look at this evidence. Do you, Judge Quisenberry? Number 7, wherefore, premises considered, petitioner requests that the court grant the relief requested herein and grant any further relief that is in the best interest of the child. And again, I would remind Judge Quisenberry, the dishonorable Judge Quisenberry, that the best interest of the child is that you consult with him about what his desires are. That is number 1. You have yet to do that for over a year. This child has been wanting to speak, and that's why I have him on videotape, because you have silenced him. And Ashley Womack's attorney has silenced him. By the way, Ashley has a new attorney by the looks of things. Scum Bob is no longer run around. It's now Stephen D. Lawrence Jr., State Bar number 24029331, 4420 West Vickery Boulevard, Fort Worth, Texas, 76107. Phone number 817-377-0060. His email is S as in Stephen, Lawrence, LAWRENCE, at LoWarren, LOEWARREN.com. Attorneys for Ashley Womack. And then the certificate of service is attached. Now here comes the affidavit by Ashley Womack. Before me, the undersigned authority, and there is Tammy Brown is the notary public who has signed this. Before me, the undersigned authority, on this day, personally appeared Ashley Womack, known by me to be the person whose name is subscribed below, and who, having first been duly sworn by me upon her oath on this state, stated the following. The first question I have is, if she has sworn by oath, is she committing perjury if she is lying? And if so, are there any punishments for this? Because the reality is, in courts today, perjury rarely, if ever, gets punished. And there are rewards for committing perjury, as Ashley Womack knows. I am Ashley Womack. I have the authority to make this affidavit. I am above the age of 21 years, and I am competent to testify herein. The statements made herein are within my personal knowledge and are true and correct. So she can allege this even though others would dispute this. I am the mother of blank, 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 age 14. Okay, we're with that. On October 3rd, 2019, at the conclusion of a court hearing regarding my son, the court had the Parker County Sheriff's Department hand over my son to me inside the Parker County Courthouse. I had not seen my son for over a month, as he has been under the wrongful possession and control of his father, Rustin P. Wright. Upon the deputies handing my son over to me at the courthouse, my son became belligerent and combative, to the point that they had to take him back into their custody and transport him to the Dallas County Juvenile Facility. I believe that when he is turned over into my care later today, that he will be further combative and is in need of intense mental health services for the safety of himself and others. Nobody who knows her son would think that he has such intense mental health issues that he is a safety factor to himself or to others. Now here comes the other part. I have located a facility to help my son. However, a temporary injunction in effect in this case prohibits me from removing my son from Parker County, Texas. And by the way, to the best of my knowledge, she has already illegally moved her son to Parker County because the orders that I saw appeared to say that she must reside either in Lamar County or Collin County as long as the father was there, and the father is still there. So it appears that she illegally moved her son to Parker County, but of course the dishonorable Judge Quisenberry does not want to look at the facts. No, 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 his mind is made up. His mind is made up. A temporary injunction in effect in this case prohibits me from removing my son from Parker County, Texas, or any contiguous county, and I believe that I cannot get my son the help he desperately needs without violating the order of the court, because the facility is located outside the restricted area. Ashley Womack is writing this. The facility will admit my son immediately upon his arrival if I am allowed to take him. I am requesting that the court lift the injunction for me so that I can take my son to this facility to get my son help for his mental and emotional well-being. I believe and fear that more physical, emotional, and mental harm will happen to my son, myself, or others if he is not immediately taken to and admitted to a care facility. Further affiant saith not. And this is signed by Ashley Womack, once again subscribed and sworn before me the 4th of October 2019. This is by Tammy Brown. So Ashley Womack is petitioning Judge Quisenberry, who I believe needs to be investigated immediately, suspended from all duties and investigated immediately to see whether he is even acting as a judge. This would be a very easy case for the State Commission on Judicial Conduct to investigate. This would be a case that legislators should look into. In fact, I believe that what he is doing is in part criminal, and he should have no immunities for criminal actions that he's taking in this case. So here is the order on emergency motion for injunctive relief. This document contains sensitive information, so I will not, again, state the child's name, but the cause number is CV18-1452 in the District Court, 415th District Court, Parker County, with the presiding dishonorable Judge Quisenberry. On October 4th, 2019, the court heard petitioner Ashley Womack's emergency motion for injunctive relief in the above-styled and numbered case. The court examined the pleadings and the affidavit of the petitioner and finds that the petitioner is entitled to immediate temporary relief. Now, what happened in the courtroom, I was not allowed to videotape. Bailiff Timmy Kane threatened me. I thought he was going to try to handcuff me and put me in jail, so I left the courtroom. They had a rule that day that you could take no type of recording equipment into the courtroom. I was in the lobby with them holding a camera, which wasn't even my own, and Bailiff Timmy Kane told me I needed to shut it off immediately and get out of the courtroom, get out of the lobby. He told me I needed to leave. Bailiff Kane is in cahoots with Judge Quisenberry. And by the way, the reason that there was no recording allowed in the courtroom for Rustin, there was a sign put up that day that said there will be no recording devices allowed because Judge Quisenberry found out that somehow there was an audio tape from the first hearing that I attended that recorded some of his statements. So once again, I don't know exactly what happened, but I have heard from other people that what Ashley is stating happened never happened. I was there when the son said, I'm not going back. I'm not going. I'm not going. I have seen in the past where he said, send me to juvenile detention. I'm not going back with my mother or my stepfather. In fact, there is a video cam out there with a police officer. And at that time, the son said the exact same thing to the police officer. I believe his name was Gary Olson. I will look up that video. And Gary Olson said, you most definitely are. And at that point, Gary Olson got upset and roughed him up, Gary Olson should also be investigated for his temper and for the damage that he did, the harm that he did to a 14-year-old child.
I'm Corporal Olson. I'm with the Sheriff's Office.
Jimmy.
Jimmy? Nice to meet you, Jimmy.
Nice to meet you.
What's your name?
Aiden.
Aiden?
Yeah,
Nice to meet you, brother. What's going on?
I'm not gonna live here anymore. I've had enough.
You what?
I can't live here anymore.
You can't?
No.
Why is that?
Because I've been physically abused.
Okay.
And-
How
and
you been
emotionally
physically abused?
He's pushed me into a bathtub before.
Okay.
He's picked me up while trying to take my clothes away and thrown me across the room.
So how old are you?
14.
You're 14. Okay. So let me ask you this: what right do you have to any of that? What right do you have to make that decision? We'll start there. What right do you have to make that decision?
Because
you're not
it's
gonna
my
live there.
life. I mean, I'm not going to live there. I can refuse to live there.
You cannot.
I
You
can't.
can't live. Nope. You can't refuse to live anywhere.
I can.
You cannot, and you won't.
I can refuse.
You can't, and you will not. So here's the deal.
Dude,
Don't dude me. I'll call you by name. Okay. My name's Gary. Call me Gary. I will completely respect you 100% until you don't respect me. Okay. So here's the thing. All right. Regardless of whatever you feel is going on, if they're the ones in charge, there's only three things that they have to give you. Okay. A roof over your head, food in your belly, and clothes on your back. They don't have to they can take everything out of your room and give you a blanket and a pillow if they want.
Okay.
Like, there's absolutely nothing that you are entitled to. Everything's a privilege. So, again, what right do you have to make that decision?
Sir,
The
I'm
answer is you
telling
don't.
you can take me back there and I'll just walk away again. So I'm asking you to take me someplace else.
I won't. And they can actually pick you up and put you in the car. And
Then
take
I'll
you there.
refuse. I'll push him back and I won't get in.
No, you're not going to put your hands on your stepdad at all.
He's not going to put his hands on me.
He can, though. That's the thing. He can. You cannot. He can, because the law gives him that right. The law gives him the right
I
to
will walk
restrain
away
you.
again. Sir, I will walk away again. You're going to take me to the house and I'll walk away again.
Okay, well, I'm telling you, it's not going to work out for you.
I'll just walk away again. I'm not going to live here. I'm through with it. The police have been out here multiple times.
And they've told you the exact same thing every time they came.
And we'll do it again.
The judge has told you
And
the
we'll do
exact
it
same
again.
thing every time. Why y'all continue to fight this thing? If you would use your brain and do the things that you're supposed to do, you're old
Do
enough.
it over and over
You're
and
old
over
enough
again.
that the judge would listen to you, and that
I'm not going to live here.
and that you could decide where you wanted to live. But the judge
I'm not going to live with
the
people
judge
who
is not-
abuse me.
The judge
That is
gonna-
not what I'm going to do. I'm not going to live with people who abuse me.
The judge is not going to listen to you when you act unreasonable.
I'm not going to live with people who abuse me.
You're going
You're
back
going
to
back
the
to the
house.
house. You're going back to the house.
I'm not getting in the car.
asking
I'm not living there. I'm not going there. We'll do this over and over again until you take me someplace else.
Here's the deal. You don't tell me what to do, buddy. I will not take you anywhere, buddy. Okay? Let's get that straight now.
Okay?
Okay?
Then
Get
we'll
in
do
the
it over
car.
and over again. No.
Let me tell you something. Let me tell you something right now. Stop. That did not work out for you, did it?
I'm not going
Now
in the
stop.
house. I'm not going in the house. I'm not.
Stop. Listen to me.
I'm not going in the house.
You're going. You're going.
I'm not going in the house.
So let's go.
I'm not going in the house. It's not their property. That's my dad's.
Guess what? They have right over it.
No, they don't. It's not their property.
Yep.
It's what my dad did. I'm not going in the house. I'm not going in the house.
Stop.
I'm not going in the house.
Not just physical harm came to this son by the police officer, but now you were having abusive behavior in which he will be admitted into a mental health facility because of the pleadings of his mother. So the dishonorable Judge Quisenberry, whom I think should be held accountable should any harm at all come to this child, there are even questions about whether Judge Quisenberry has any jurisdiction in the matter, but Judge Quisenberry will not even look at that evidence one way or another. he is going to be making this decision, and he is going to make sure that the son gets admitted to a mental health facility. It is therefore ordered by the dishonorable Judge Quisenberry, Graham Quisenberry, dishonorable person. It is therefore ordered that the injunction set forth in the temporary orders signed in this cause on September 20th, 2019, which reads, "It is ordered that neither party may take the child beyond Parker County, Texas, and its contiguous counties until further order of the court, is hereby lifted and modified as to the petitioner. And the petitioner is specifically authorized to remove the child from Parker County, Texas, and contiguous counties thereto, to seek and receive educational, medical, psychological, and psychiatric care for the child." And this was signed by the dishonorable Judge Graham Quisenberry, October the 4th, 2019. So this child, who was very content, very happy living with his father, very well taken care of, was enrolled in a home school. I saw the report cards. The report cards, the lowest grade he had was 1 or 2 88s, and the rest were 89 in the 90s, and he even had 100. I saw the report card, but somehow his educational needs are not being met. His psychological welfare is not being met. We're very concerned about his psychological welfare. All he has said is, "I want to live with my father." And by the way, this dishonorable Judge Quisenberry, who seems to disregard any type of restraint that should be placed upon this judicial activist, that he's completely ignoring the fact that he should have taken the son into the court, into his rooms and chambers, and interviewed him to ascertain his wishes. This son so much did not want to go with the mother and the allegedly abusive stepfather that he said, "Take me to JV." And by the way, once again, he said the exact same thing to police officer Gary Olson before Gary Olson got mad and roughed him up. So this is what is happening. The next hearing is going to take place in Parker County on Friday, October the 18th at 9 a.m. And we are asking you to come and join us. We would like to have media there. We would like to flood the courtroom. We would like to be outside of the courtroom. What is happening in the state of Texas, and it's particularly in Parker County, is appalling. It is horrendous. And for a judge to be given the ability to destroy the bond between a son and a father without any reason to do so, and perhaps even no authority to do so, this judge, if these things are true that I'm alleging, should be prosecuted for criminal actions, should be impeached, and should be imprisoned. That is my opinion, and I stand by it. I hope you can come to join us and bring light to this catastrophe of injustice that is taking place in Parker County, in the 415th District Court, under the dishonorable Judge Graham Quisenberry. Thank you.